We listed only.
What admission?
ଦେଇଦିଅ ସେଠି
Why admission?
ଆରେ ସେ ତା ସାଙ୍ଗେ କଣ ସମ୍ପର୍କ ଆମେ ସେ ତ ମେନସନ ମ୍ୟାଟର କେମିତି କଣ ଅଛି
ଗୋଟେ ବନ୍ଦ କରି ଦେଖିଆ
Yes. Who's to start?
Fact, reference was made on the basis of the submission made by the State Council. So, Mr. Last occasion, your lordships had directed Mr. Mishra to, because he being the amicus appointed in this case.
Madam, this is a special bench. This is something where all the three persons are sitting for this matter only. We never heard that somebody is on legs in another court. For special bench, I think then we have to just sit idle because we can't proceed on that basis. And there is a frequent mention when this matter is going to be listed, why it is not listed. Many things are coming, why this matter is not listed. When we are listing the matter, nobody is there to argue.
Your senior is not available.
The Lord Council who made a mention for listing of this matter, he is also
Every time there is a usual.
he
The
himself
difficulty,
not
the
present.
difficulty with all humility and the respect to my, the difficulty is that going to the administrative officer instead of coming to the court. I think the lawyers should mention in the court if they have any difficulty. Why they will go to the administrative office? I think this is not a decorum. At least I am not groomed. Then what to do? Should we sit idle or what to do? Nobody is here to argue. Matter should be listed. And when we are listing the matter, there's no.
Even the respondent is mentioning repeatedly, he's not. It's very confusing.
Does not percolate a good signal. You see everything, but who is the arguer? You see everything, but who is the arguer?
With despite all sincere effort, no document could be found either by the department from the director of prints that if there is a gazette notification declare such manual even post independence to be
Supreme Court judgment is very clear.
Very
that it
clear,
has no
but-
statutory force.
but
Then
but in the meantime
we'll have
my lord,
to go by the mandate of the Supreme Court.
but in the meantime my lord, one judgment of this honorable court, Odisha High Court, in case of Dharmanand Harijan by Honorable Justice G.K. Mishra, the then Chief Justice, and K.B. Panda, where the issue was whether the the Odisha Civil Service Classification Control Appeal Rule 62 is applicable to police force. That was the issue. There, the Honorable Court, while interpreting the provisions of police manual, has come to a conclusion that it is a complete code unto itself. So the statutory rule of 1962 is not applicable. So that is the judgment of it. The Honorable Court, my lord, para 13, from para 13 they have examined the rules, and para 23 is the relevant observations. Rule 853 confers the power to certain authorities to call for the records. It says the governor, the inspector general, or the deputy inspector may call for the proceedings in any case, even where no appeal lies, and pass such orders as may seem fit. All the aforesaid rules are marked with asterisks and are statutory rules framed under Section 7 of Chapter 5 of 1861. Those rules and many other statutory rules in the Odisha Police Manual not referred to in this judgment constitute a complete code regarding classification, control, and appeal corresponding to 1962 rule prescribing the nature of penalties, the authorities to impose the penalties, the case where the appeal lies, the manner or the disposal of the appeal, and the authorities who can review an order and in what circumstances. Then next, last but one paragraph, they have said in terms of Rule 31 of the 1962 rule,
45, the power of review provided in Rule 32 of 62 rules do not have any application to
do not have any
service.
application because this is a complete code unto itself. So the classification. So this is the, so far as this High Court is concerned. But so far as the Supreme Court judgment, your lordship have seen. And last occasion, my learned senior, who is also a member of the Law Commission, lordship's last order, your lordship may kindly see. Order dated 28/11/2025.
Yes.
Now, my lord, there are.
No, I understand you are here. The learned amicus curiae is also here. But what about the parties? The matter was called where you were. No, sir. This is not expected.
Sorry, my lord.
This bench is sitting only for
Sorry.
this matter, and there has been a constant mentioning of the matter at your behest.
Sorry, my lord, that
On the administrative side, why the matter is not listed, why the matter is not listed. This is not a way. When it is listed, special bench, nobody is here.
my lord, in this particular case of Manoj Kumar Bala, which is the lead case, there the learned he was the counsel who made a mention.
When the matter is called, nobody is here. Outside, when the courtroom, there are many things.
And now, given the position of law in terms of the Supreme Court judgment, it may, your lordship may also hold that whether the reference is at all required to be answered. That is also because
No,
once
if
it
there
is not a statutory in
there is
nature.
already a deciding case
Yes.
of a Supreme Court, then even a reference can be answered in the light of that judgment. There is no difficulty. Why the court will say the reference is absolutely, it was not warranted.
But the development regarding law commission, my learned
Yes,
senior
you
can
said that
address.
you are in an active consideration or something like that. If we correctly remember last, and you say that you adjourned in the meantime, will take a conscious.
Delivered about the council meeting also, commission meeting. So there actually the Supreme Court judgment that has been referred to, that Ajay Bhuiya's case, that paragraph 14 particularly, if your lordship looks into that, the Honorable Supreme Court has said some of the provisions of the statute has got the assent of the government. Because section 12, rule 12 itself says that the IG police, now DG and DIG, they are authorized to frame rules confirmation of the government is required, approval of the government is required, and then it can also be implemented. Article 313 and all that. But some the provisions where there is an asterisk mark at the bottom of the section itself, where it has got the assent. But the question is, if your lordship looks at those provisions, some has been done in 1993, some has been done in some other dates. So those are all amending provisions. If your lordship kindly visualize that, we deliberated upon and called upon the law department to find out those related files which must be containing the original file. And that was also discussed. And we have said, relating to those provisions where the asterisk mark is there for actually the governor or the government, then you relate back and find out 1940 whether actually this manual has been approved by the government or not. But they say the apprehension is it must be under section 12. There is no other provision except section 12, which actually is conformity with the Police Act itself, 1861. So unless that is approved, the rule could not have been made applicable. So the amending provisions are there asterisk marks. The Honorable Supreme Court has taken note that. And Supreme Court said all the provisions have not been given. There is no material before us to find out. At that time, nothing has been produced also before the court. But if your lordship looks into that, and this has been followed since then, till now it has been followed. In the number of cases have also been filed. We found out the law department said number of cases in the High Court is also pending and relating to the same subject matter where the punishment has been given. Particularly, this provision, if your lordship looks at that 835 rule, if you also kindly look at that police manual 835, effect of black mark ballot. 835 ballot. 835.
Yes.
So there is an asterisk mark if you also looks at in that section, rule itself.
Yes. Yes.
In the bottom it is mentioned.
SDN number.
Yes. And
1992.
Then OPG serial number 44 dated 15/2/1993. This is a 1940 rule. So these must have been incorporated in that year. And
by way of amendment.
By way of amendment. So we have also asked the law department to test out those files which relates back to the original file itself. So that must be there. But they're still working on it. Unless they give us the feedback, we cannot work out. So we have asked them, law secretary was also a member. He also assured us to find it out. So we are actually deliberating on this issue also. Because this cannot be without any basis. There must be some basis because the Act itself is 1861. And that is the basis on which this rule has been framed. And Supreme Court has taken note of this. This as mark in the year that has been incorporated in different years.
That's para 14.
Yes, para 14. If I may just read it, para 14, if your lordship permit me. The decision is there before lordship.
Judgment of the Supreme Court, Ajay Bhuiya.
Ajay Bhuiya's case.
I think this is the file.
Give them. I got it. That's all right.
This is the
Para 14, huh?
para
Yes.
14.
Para 14. We have gone through the police manual. The entirety of the so-called rules contained in the manual are called rules not because that every one of them had statutory backing or source of its origin in a statute, but were rules designed for uniform application in the police department at the level of DGP/IG and below, even at the district level. No serious effort seems to have been made to scan those police manual, which contains preface note that Orissa Police Manual 1940 contains the rules made by the state government and the rules and orders framed by the IG of police, presently DGP and IG, with the approval of the state government on the provision of Police Act 1861, are issued under the authority of the government to be binding on all the police officers, and that it is an authoritative guide to officers of the department. In sum, only of the rules printed in the book, on going through the body of the manual, we find that an asterisk mark is assigned with a footnote that there were rules made under section 12 of 45, the Police Act 1861. Again, in respect of some of the other provisions, indications of the statutory provisions of the Criminal Procedure Code or other authority, provisions under which they have been made are specifically mentioned. At the top, some of the chapters, particularly chapter 20, relating to appointments and engagement, a specific note is found printed that rules marked with asterisks have been sanctioned under Section 7 of the Police Act 1861. The conspicuous omission of the absence of such specific indication either in top of chapter 27 or in respect of any one of the so-called rules enumerated thereunder, are as their nature and character are showing them to have any statutory origin, it has to be presumed reasonably and necessarily to be not statutory. State of Rajasthan versus Ram Saran, this court had occasion to consider this aspect and hold that only the rules or orders passed by the government under Section 2 of the Police Act 1861 alone can be held to be constitute conditions of service. The rules envisaged to be made by the Inspector General subject to the approval of the state government, even under Section 12 of the Police Act, were considered to be not such which could deal with the relatable or relatable to the service condition of the officers recruited to the police force. Even the decision relied upon by the tribunal for its conclusion, the state of UP versus Baburam Upadhyay and Jagannath Prasad Sarma versus state of UP would go to show that when was considered to be continued by virtue of Article 313 of the Constitution of India as existing law, where only those statutory rules or regulations made in exercise of the power conferred by the government and rule Police Act 1861, which stood prescribed, reserved under Article 243 of the Government of India Act 1935, and therefore held to be continued to be enforced even under the Constitution, so far as they are consistent with the provisions of the Constitution. Laws in force for the purpose of Article 313 of the Constitution of India were considered to be only those which are framed in exercise of the various statutory powers vested in the government, including the powers under Section 7 of the Police Act, and not to confer such statutory character to each and every one or other of the so-called rules. As a matter of fact, in Union of India versus Majis Jagamaya, repelling the similar plea urged in respect to the administrative instruction of the government conveyed through the Central Board of Revenue, it was observed that administrative instruction or order is not statutory rule, and that Article 313 does not change the legal character of the document. They have said Article 330 refers to law in force, which means statutory laws, and administrative instruction or order is not a statutory rule. The rule that were under consideration in this decision of B.N. Nagarajan versus State of Mysore were held, though, not to be made on Article 309, but traceable to the power of the government under Article 162 of the Constitution of India, and therefore binding in the absence of under rules under Article 309. It cannot be said of the police manual of the year 1940. Consequently, the baseless assumption of the tribunal, which rendered the decision on the view that rules noticed by it had the statutory existing law without specifically pointing out under what provision of law they were or could have been made, is totally erroneous. And for that reason also, rehearse the binding nature of the earlier decision of the tribunal, as well as this court, and despite the judicial norms, propriety and decorum violence also cannot be justified in law on merit as well.
So it says that even if any rules or any kind of an orders which are passed prior to the adoption of the Constitution of India,
Correct.
if they have no statutory backing or if they do not trace any source of powers to make
313 cannot
then
protect.
Article 313, the existing law or the law in force cannot be construed in this regard.
Correct.
And if there is no documents which are forthcoming throwing light on the issue that it is a statutory force, has a statutory force, the presumption is that it is not. It's merely an administrative. is the
crux of the
crux of the paragraph 14?
But the best example is the Odisha Service Code. If your lordship may kindly see, it is also a pre-independent statute. It was framed under the provisions of the Government of India Act.
That is
And after the commencement of the
correct.
Constitution,
Then it is.
it was declared to be a law under Article 309 of the Constitution.
Has to be.
Yes, but
because,
in this
because
case,
you trace a source of power.
yes,
If you trace a source of power, maybe under any of the statute which was prevalent at a relevant point of time,
prior to
if they are not inconsistent with the constitutional mandate or a ethos or
That will
I
hold
would
good.
say the
Even-
morality of the constitution, then in that event they will continue. But if they offense, then they are not.
they are.
In the supplementary relief mechanism.
Quarrel. We
Yes.
were trying to fathom upon these issues whether it has any source.
They're searching for.
For research,
My lord, nothing is available in the state archives or law department or revenue department at such everything. Only I got this three documents. There is a police, PR Odisha police manual of
that is what is
there. Nothing more is available, my lord. So the terms of reference can
that is
be
the
answered on the
1930. That
existing
is the 1930 manual.
manual. So after that, I could find nothing from state archives or any of the source in the government press also. No, here nothing is available. My lord, terms of reference can be answered on the existing.
No, this is available in the internet.
I got it from the state archives.
No, this one is available, but where is the book?
I can say that they are documents in the.
So these are only the index.
That is
Is only
available.
the index. Huh? Where is the?
This is available in the internet also.
internet
part.
is there.
May I reframe my word? It is really a menu, but where is the actual food?
That can be downloaded from this. That is available.
Not available.
Provision of this code is
You have said page 1 to 26 is a police hire. Then you say 27 to 35 power delegated to. But where is the provisor?
No, nothing is written regarding the statutory sanctity of this.
These are all the
manual.
index only.
I never got it anywhere.
Where today where we stand is there is a judgment of Supreme Court which is binding.
Yes.
So if the reference has to be answered, it has to be answered in the light of that judgment. There is no doubt.
Correct.
Second is otherwise we have to wait till you search the
Exactly.
source
We have
and
asked
tell
them to
us.
provide.
This is the true
because-
situation.
That is the reason is that if we go by this Ajay Bhuiya's judgment,
Yes.
and we go by that, you have not been able, not a state has been able to find out any source of powers
Right.
regarding this, then the presumption would be that it is merely an administrative or an executive document,
Correct.
which is not legally enforceable, nor can be projected as a consequence against a particular person, because
That is the law.
really going, that's the law. Then the answer would be straight away that if this power has no statutory flavor, then you can't mark it, then everything has to go. There is no provision for making blacklist marking or something like that. It has to be erased from the book.
Entirely,
sir,
there
I
will be
have-
no proceeding against a police
That is
officer.
what I'm saying. That is a
Cost
has
cutting
a
effect.
far reaching concepts.
And police manual, not only it consists of
Because
the departmental
it
proceeding,
appears,
it also
appears
consists
that
of promotions, probations.
you have been religiously, rigorously,
Following.
and continuously following
Following.
everything.
Right.
So what to do? That's why we are every time we are waiting, but the respondents are not waiting.
You are mentioning every time.
In
Right?
administrative side,
But one reservation is there, if you permit me, those provisions which have been amended, incorporated in the statute itself by way of amendment, the asterisk mark, those have got the sanctity under section article, sorry, rule the 12
If
of
it is
the,
amended, if it is
Yes.
amended provision, that also you are not sure about.
no, we have asked those files.
No.
Those files only at least tell us.
Mr. Mishra, there is another question. If a particular whole of the bunch
Original.
of the statute does not have the statutory
Then it cannot be.
recognition, why what of amendment can you make it a?
Right.
The only thing is, if we get that document file, then sir, we can relate it back to the original file. That is
But
exactly
still we are square one.
so,
It is just like Odisha Service Code, which later on they are also executive instructions.
yes.
Later on, that is adopted as if it is framed under Article 309, I think.
No, my lord.
No, no.
Service code was framed under the Government of India Act
Government
of
itself,
India Act.
1935.
1935.
35.
It was
And-
framed under that act. So it had a legal basis, some legal basis at that point of time, and subsequently it was declared to be a law under Article 309
That is what I'm saying.
after post the constitution.
Because it is not inconsistent with the
Yes,
spirit of the
spirit of the
constitution.
Yes,
But that is not so in this case.
no, yes,
That's the difference.
that is the difference.
That's the difference.
What to do,
Can
sir?
you have
Tell us,
mentioned,
give us some
more time?
code. We can't decide the matter, say in vacuum.
My lord, for more than
You-
100 years,
we
this
appreciate your
manual has been
concern.
followed.
We appreciate your concern. But the difficulty, please appreciate the concern of law.
My lord, for more than 100 years, this manual has been.
So you said that it should be followed.
You
We'll
show-
say
my
so.
lord,
You
lord,
show as a judgment of Supreme Court. We say that if it doesn't have the statutory effect also, if it is consistently followed for years together,
It protects
has-
the character of law.
character of law. You show us the judgment.
I have not come across. If you can show us.
That's your job.
my lord, if the manual has no statutory sanctity, then all the proceedings.
Don't
must-
presume, sir. We have research on all this. Don't presume things. Tell us. You are the you are supposed to address us.
My
And
lord,
you are
no-
mentioning you are making hurry to be decided this matter. You have to tell us. Come with some material.
my lord, nothing is available from any source and list. That's the
Then
problem.
how to decide? Tell us that what the court will decide. Tell us in what way. What should be the correct way? Should I take it that none of the councils have disputed the statutory recognition of this particular manual? So we proceed to decide. Can you say so? Suggest. Or we say that since no argument is advanced, so we proceed to decide. Or we have to then
Ajay.
wait and decide whether it has a statutory recognition or a flavor.
With lordship permission, may I suggest one thing? But summer vacation is coming very fast.
So the difficulty is that we were really waiting. Our last order was that we say that these are the things.
Yes.
Then we granted a liberty to mention, so that if every collation has been done, every documents have been collected by you, then you can mention. We can sit and then decide. But there was some kind of a
We will-
I understand.
persistence was there.
we expected
Why
that you will
you're not
mention.
sitting? Why you're not sitting?
We were expecting that you will mention after collating all documents so that we can.
No,
That was
in
the
fact,
idea.
but we are
That is
discussing.
not coming to the administrative side. When it is sitting, when it will sit. And the
That's
PR
it.
listing is coming to me and then say that this is the letter I have received, what to do.
Immediately after summer vacation, if the Lordship list it, I think we can expedite the things. And
You
Sir,
must
we don't
understand, it is
mind.
not a single
No.
case. It has a cascading effect in many cases pending in this court. So you can't single out your case, decide it. So why are you making us hurry? Research is going on and they are not doing anything. Every time you are shooting letters.
Have you got any material?
No, I have tried to collect all the materials.
Just imagine.
Except that I have gone through that. Your Lordship has gone through that.
Your
document.
junior is persisting for listing this matter or sitting of the
No,
bench?
no, my lord.
Is
But
listing you.
my learned friend is.
You don't have a material and then you are insisting.
At least we should have been informed that he has
But you know
not.
what? The irony is that if you come and mention the matter before the court would be in a position to ask whether you have completed, ask the other side whether are you ready with
Yes,
all
ma'am.
the matters. Then we can definitely list. We also do not want that reference should remain unanswered. We really wanted to answer all the
And
references.
it is a batch of cases. We are not informed. My lord,
It has,
but
it
the
has
entire
a
problem.
larger impact.
Yes, ma'am. That's the larger impact. My lord, I have.
But if you go in administrative side, every day writing a letter, this is not
My lord.
appropriate. Unless you are ready, no problem.
Yes.
We don't mind. But you yourself is not ready.
Sorry.
Of the Act, 1862 Act, is defective. Many states of India, they have amended, they have made their new manuals,
But
except
but
Odisha
they
and
do
some,
not. They have no document that it has come under 12.
near about 15 states have they amended
Sir,
their
that
manual.
is- every state may have ratified by virtue thereof. We do not know. But here we do not find, because that is what we are harping on that.
Right.
The senior counsel who is also there in the committee,
Yes.
he is also pondering upon that issue and just trying to find out any document
Source, right.
which can throw light on that. And they talk about the documents of 1940. If I correctly
Right.
remember, you said 1940. 1930 document, Bihar and Odisha police manual, you have said 1930, but superseded by 1940.
The creation of separate state of Odisha in 1936, the manual has been framed in 1940.
Show us. Sir, what did you show us? We are ready. That is what we are, I would say, breaking our head to find out whether it is. If you can show us, that clinches the issue, sir. If you can show somewhere, anywhere, one notification, one document that it is by virtue of this provision. No problem.
There is no such.
We are unable to find out. He is also not in a position to find. And this manual, it appears it is in 3 volumes, but you have simply gave us a 3rd volume. What about the 1st and 2nd volume? I do not know. And that too.
Second volume is there. That is the procedures laid down in that second volume.
Here there is the sanction of the government, the authority of the government of Bihar, Odisha is there. I think it is statutory portion.
Where?
So on the front page, my lord, is written.
The last page you have given a letter. The letter is something different. This is what you are referring, sir. I'm looking at it. This does not really throw light on
No,
that.
no, the front page mail issued by the and with the authority of government of Bihar and Odisha. So that's
Which-
why I think it has some
Which one?
statutory force or sanctity. We are Odisha police
if your
manual.
lordship-
That part
No,
of
this is
Odisha manual
first
has
thing.
been framed.
No.
The origin is Bengal
But
police
this manual, so far as this police manual is concerned, it draws its lineal descendant from Bengal Police Code.
Oh, true, I know.
The forward, if your lordship may kindly see the forward of that manual which I have collected from the department, 1940 manual. Your lordship may kindly see that forward, what it says.
This manual is a linear. This is another Bengal Police Code. It's a linear descendants. This is what is forwards.
What is the position in Bihar? Whether that is notified or anything of that sort?
The lowest panel
They have 78.
Correct. Yes, earlier it was.
His preface talks about some.
Preface,
some
it has been
statutory.
framed by the state government. That is what
Yes, but where is that?
that basis.
Look at the preface.
So we have-
Yes.
What we know. How many
The preface, what they are giving, that shows or that reveals that there are certain
Yes.
rules framed under the act or which it receives the recognition of the government. But where are those documents are not clearly come.
That is exactly we are trying to.
Look at it. This preface says something. Hey, this preface though indicates something, but is a Odisha police manual. From there they have got this. But
That's that book my learned friend is referring, that is not that 1940 manual is different. It is from Bihar, Odisha government. So the only
no. This is under the Odisha.
yes, that
They talk about the Odisha police. Saying that it has received the concurrence of the government of Odisha.
yes.
My lord, here is that is the approval of the state government.
Oh, that is what they say.
This is
But
the
that's
the
not
original
the-
document is
Because this Ajay Bhuiya's case, the Supreme Court has said there is nothing. So this judgment, Supreme Court judgment really runs counter to this.
yes. And I could also find out one notification where, keeping in view the judgment by the Honorable Supreme Court so far as the directions with respect to Panchnama, evidence and everything. But the By the order of governor, the Home Department has amended certain portions of this police manual. If your lordship may kindly have this. And again, how they are amending when the basis is not there.
Absolutely.
But that is
That is the whole.
every time I'm getting confused if your lordship may kindly. And that notification is by the order of governor. That this is true.
I think you have to set it right now. With this problem.
Addendum. Should we proceed? What?
Not accepted today, then all the decision taken out of this will be in the
That's
wild of
true.
this.
That is what we are more concerned about.
So it is had been followed since 1940. It has force of law almost and
So
procedure.
that's why I say there are three courses, either on the basis of your consent, since you are supporting the state in this regard, saying that it has a statutory force, no problem. State has ample authority to do it. Then we have to go on a
Then, my lord,
consensus.
in
Is
my
it a way of deciding a law? I ask. On a consent, a law is decided. When Ajay Bhuiya's case, in that it was a Odisha police manual where the Supreme Court has said otherwise.
And that consent will be against the judgment of the Honorable Supreme Court.
Can we say by consent the judgment is wrong?
See, the state has to find, you are in trouble. You have to find out the way. You can't leave it to us. We will answer in the similar fashion as the Supreme Court has said. What will happen thereafter? You will be in soup. So you have to come out with some solution and tell us that we are going to do this or that. It is your responsibility. Why the law commission will only suggest. Eventually you have to do.
We have to recommend actually, we have to.
Are you not, after so much of deliberation in this matter, have you not advised your government to take steps?
We have advised, but
Then
the law department is
don't
also-
take it as a simple a matter. It has a larger ramification in thousands and thousands of cases,
even to the pending cases.
and you will be in trouble. So you have to come out with the solution and tell us. We are taking legislative steps or X step or Y step. You are adding to the problem, saying this happened, that happened.
I think my
And
friend
even
will
if
agree.
the law commission
that
will
my friend will
gives a
agree
report, it is a suggestive report to you, opinion, you have to carry out that.
because-
By now you should have done it.
So that
You after knowing all these things, you have to give a comprehensive answer to this court. What are the steps you are going to take?
existing law. Existing law.
What to do now?
So my friend has agreed that if you are fixed to after vacation, we'll just definitely work out and we'll take a final call on that.
You learn an amicus curie.
least.
His name is not reflected.
Okay. Whose name?
The magistrate.
I couldn't see the least yesterday.
It is reflect everywhere in all the cases.
Particularly from law department, you can get instruction after 2003. Ajay Bhuya,
Yes.
any step has been taken?
Law department, my lord.
The law department has not read the judgments.
But law department, my lord, the secretary to the law department is the ex officio member of,
No, he
This
was there at the
commissioner.
meeting.
But after
And it has been-
2003, you should have taken some steps.
yes, nothing has been.
What step
That
you have taken?
After Ajay Bhuya case, some recruitment rules have been framed.
So what you have done? You have done after 2003.
Ajay
Bhuya,
Ajay
tell us.
Bhuya case itself was a case of recruitment, but there they have interpreted, so far as the police manual is concerned, the honorable court has given the finding.
Particularly the asterisk part.
Asterisk marks. So this police manual not only deals with the departmental proceedings, but also promotion, appointment, recruitment. So
That's why we
after
we-
this
we
Ajay Bhuya
recorded that
judgment,
it has got
they
a-
have framed separate statutory rules so far as recruitment is concerned. But so far as
You tell us the next date of hearing.
Well-
What have you done after
It
2003?
is a far-fetched consequences, so we were really going very serious and deep into the matter. Yes, then you have to rise.
Lordship, what I pray, my lordship. Lordship may permit me to file a fresh representation, and that representation may be disposed of in light of the order passed by your lordship in case of that Prashant Kumar Mahanti, my lord, so NGT, my lord. Here, my lord,
Extension.
Yes, what you say?
No, no,
Yes,
his application has already been rejected. Why
What,
does
what,
one?
then it is
my lord,
So
rejected.
now
my lord,
60
it is
election
rejected,
64,
not considered
64.
here.
64. You are relying on rule 64.
My lord.
Has rejected.
Yes.
Government rejected.
Yes, that is under answer one. Suppose rejected, you also directed, pursuant to lawsuit direction, matter was considered. After
No, government
considering
has
the
not
matter, that has been rejected.
Answer one.
Not pursuant to your lordship's judgment, Pratap Kumar Mahanti, my lord. It was
So
a mere-
whatever, we have simply said that it is a conscious decision they have to take. That does not mean that it should be allowed.
My lord's not in that sense, my lord. In
No,
this
it
case,
is
the
about-
Pratap Kumar
let us
Mahanti,
say
lordship has
this
said that in view of they are not
No.
allowing me to complete the query, my lord, they need
So
What is not the law?
considering come to page 19,
Yes, I'm,
that is the third paragraph from the bottom.
yes.
The collector himself is saying that it is the government who can do it. So let them
No,
approach the
you-
government.
Your lordship has directed earlier this application is filed by him. It is to be considered and it is
So
found that
now the
legally.
collector say that I have no power. He is correct. You are not
No, sand is not coming under the.
Mr. Swai, collector is not the government. It is the government who can relax. So that is what Prasanta case is. Government has the power, let him move the government under rule for
That is
64.
what we 64.
Yes.
The collector himself has said that it is the government who has the power to do it. I can't do it. Correct. He is correct. So let them approach the government. If the government does it, no problem.
But the earlier direction was taking the consideration rule 8 and the 64, both have been taken into consideration and already
Can he take
now
can he take
both
a
has
decision?
been passed. Now it says only 60. Now it says only taking into only 60. Collector has not
What understanding of this thing?
no, collector has not exercised rule 64 power, sir. He cannot. That is what, sir, you see, last but 3 paragraphs. I got all this point. The government has the power, government has to do it.
Where is the better? He can approach it because he himself is saying that I have no power.
We have not said anything in that. Have you seen that Prasanta case? Please appraise it. I know. See. So we have said we cannot direct for extension of leave. It is the government who can relax. Let him approach the government. That's all. For certain circumstances, he could not operate. Right?
Well, because of operation of an interim order, I was not allowed to operate. There was vegetation by the villagers, my lord, and later on it was found that the allegations were false. The inquiry was conducted.
The Tahsildar stopped you.
My lord, I was not allowed to be to operate. There are several representations filed by the villagers annexed as
Was there stopping your operation issued by the mining officer or the Tahsildar? Was there any order or a collector? Any order was passed?
the PIL also, PIL was also filed by.
Whether there was any restraint order on you to operate? Any order was issued by the authority? I'm asking you simple question.
Hello.
Due to obstruction of provisions, the same as
It has been reflected. The Tahsildar admitted that the mining operation stopped from the source was stopped for the year 2019.
2024 issue when the procedure
Item number 2.
Yes. On Sunday, your lordship has directed that council to that council to obtain the documents related to the tender. The order is not uploaded for the order is not uploaded for that reason I could not go through.
I think I dictated the
Yes.
order in the open court
Yes,
in a
sir.
loud voice.
Yes,
So everybody knows about.
yes.
The only point is that ongoing war,
Oh, that is what
Yes.
I'm doing. It was
whether it is prior to the last
find
day,
some discrepancies into
yes, yes,
Yes, sir.
into two documents.
in the web portal and the hard
So
copy
we
document.
wanted to ascertain from.
My lord, we don't have any issue, but we want to finish up the matter so that the war can be.
Sir, what is your
I was not there in the last occasion, but I will find you, Lord.
who was there? Mr. Sasuto Das.
Lord, there is no letter has been issued, Lord. Perhaps the direction was to issue. No, because this.
No, not
No,
it.
no, it was not a
Superintending engineer Bhanjanagar of Pasca.
This is the superintending engineer PH division Bhanjanagar at Chhatrapur.
Maybe because the order is not uploaded, that is why we were, there's no.
Yeah, noted down. That day we specifically said.
Your lordship,
Note down
detected
which
the
of
order.
the authority.
Everybody knows that.
Then my lords may grant one opportunity, Lord. I'll have to call the matter next week.
Keep it on next Friday.
Madam.
May I am a successful bidder. I filed an intervention petition. Not required.
Entry model main point.
Friday, because Monday they will not be able to
Yes.
secure.
Entry model main point.
Tuesday is a holiday.
Yes, sir.
2 days.
Entry model main point.
Wednesday can't be. Wednesday or Thursday. Oh,
You want to do it somewhere? I can.
no.
When Friday it has been kept. Entry model they is there. That one.
This is. You want to do it.
Right.
Item 3, sir.
Here.
Just now I received the counter from the.
Yeah, but,
I'll just. And the intervention has not solved the copy. So
Yes,
he might have.
I just
Copies in 17/4/2026.
I have not.
I have the proof also.
Well,
I have taken the printout that I have solved the copy. These are the printouts.
procedure.
Soft copy I have solved. I have mentioned that I have tried several times to solve the hard copy, but you denied to this.
No,
and you said,
when I denied, last time I got before this honorable court, I have not.
I will have
not solved the copy.
74 till
Yeah.
70.
Mr. Tripathi, Mr. Please, Mr. Tripathi, Mr. Tripathi, you have extra copy? You have extra copy now?
Yes, sir.
Right now you serve. Right now you serve. Please, Mr. Raghu, please. Mr. Karunakar, please.
Will you like have both? I have for stay of vacation and I have for intervention, both the copies, hard copy I solved.
What is your problem?
Ma'am, I'll just clarify certain things if your lordship permits me. Ma'am, filing a reply today, may I just clarify what has happened? There has been a case of petitioner intermingling two things which are distinct and separate.
You are
And
appearing
it-
for.
I am appearing for the corporation, your lordship. That is opposite party number 213. My lord, I have filed my lord, we have filed, my engaging counsel has filed power on behalf of 3. 2 is absent because he has been sent to West Bengal for that election purpose. My lord, authority could not be filed, but I have filed a reply. I have indicated that a person to be eligible to participate in any government tender has to first register himself in a government portal. What he has done is he tried to register in the government portal. That has not happened. So that action, my lord, is finds place in the writ petition. Now, what he has done, he is saying that I have applied for tender, it is not done. He cannot participate in the tender because his first place is not registered in the government portal. So he will only come
if he is granted with a registration number, which he has to upload while participating in the tender process, any tender, leaving aside this tender itself. So therefore, there is a distinction. So now what he has done, by virtue of your lordship's interim order, this tender process has been stalled. Now he can say any tender anywhere happening has to be stalled because I have not been registered in the government portal. So my lord, government portal, he should be registered or not is a distinct and separate thing, and participation in the tender is a separate thing altogether.
Registration with the
Pilot,
do you have the registration?
tender procurement sale is there.
Let's
And I have to register my name there, and as well as I have, that is, I upload the tender paper. That did not, my lord, here,
He's taking a very, I think, a specific plea.
yes,
He says that only a registered person,
yes,
who is registered with the government, can apply for that tender. Now, have you registered yourself? You have been registered. Show us.
Page 61 for it has not been registered. Page 61 of the writ petition.
let me complete first, my lord.
61 of the
That
writ
is my
petition.
case, because your lordship come to page 61. My, when I first, I register, want to register my name, they did not, this tender procurement cell did not register my name only because of the deficiency of the license. That is of 61 page. When a transaction is going on, you also see page 58 to 61. Every day.
License. What is the license?
My license, this is the license is not required. License means that is the labor license. Labor license. Yes,
He is trying to mix up.
No,
let me complete first. Let me complete. Yes,
when this bench has granted an interim order, that means that this bench was satisfied what he was saying at that point of time. So let us understand what he said. Let us understand.
Let first from PLRC come to page 26. Tender paper point, that is 5.2. 5.2. There PLRC then
Yes.
if bidders shall have experience in rack handling and transportation in the manufacture, PSU, government department, government agency, PSU, public limited company, private limited company, dealing in field of fertilizer, food grains, cement, sugar, post gas, and any other commodity. The bidder should have carried out in immediate preceding 3 financial year, so and so, at least having the average annual turnover like so. Thereafter come to page 5 plus 5.10 28. Page 28 plus 5.10. A bidder having no prior experience of handling operation as detailed at clause number 5.2 may submit the tender without copy of the labor license. If we have SI code number, etc. In such a case, if the bidder is found successful after opening a financial bid, he or she set out to execute the agreement, but he has to furnish a copy of the labor license and under the provision of the contract level so and so. Whenever the petitioner upload this paper for registration and he was restricted, he was refused.
I got your point where you are heading.
Yes.
So according to you, this license pertains to a labor license.
Labor license. Labor license is not mandatory. It's not required.
Understood.
Yeah, 61 page. Come to 61.
Yes, I have seen that you have
rejected.
License having not uploaded.
The duty of the procurement cell is only to register and also procure the tender papers. When I was restricted, the petitioner was restricted to register. Unless he registered, it is not cannot submit the paper. When in the transaction going on 16 to 18 last date, your lordship come to page also 58. Whatever is this transaction from the this is the answer and it's also this message your lordship thing. This is the 58 page 58 NSO 2 series. your lordship see, this petitioner was very intimated. This mail is regarding the pending documents verification of bidders Smarak Naik is a petitioner identified for the Odisha tender e-procurement system portal. The last date for the tender submission 16. Hence, I request you kindly approve the document so the bidder can proceed with the tender participation. We request you to kindly help the regard and oblige. This is the 58 is the transaction that is 14th March 10:20 AM PM. There are around 59, page your lordship page 59. I requested, I request you to kindly look into the matter mentioned before this thread regarding the pending registration approval of my bidder ID, so and so, my lord, the earliest age, because today is the last day of the bid submission, and I submit my bid only after your approval. Thereafter, my lord, only this is the on that is 16 March. 16 March the last date. He has also requested. Thereafter, only my lord, on the same 16 March, I request you kindly approve. Thereafter, my lord, I request in the last in the last your lordship, I request you kindly approve my bidder registration as because today is the last date of applying the tender and it is not possible to submit the document that are being asked before acquiring the tender. I take that on acquiring the tender, I will duly submit his labor license. This is the last transaction, my lord. On that is the that on page 16 or 61, you was refused. That is the answer that your registration are rejected due to the license has not been uploaded. Only he is ready to he submit after approval registration. He is required to submit the tender paper in the same tender paper. This is a procurement cell, duty of the procurement cell to register and also procure the tender documents. But he has not been registered, nor that's why he is deprived of. That's why he has come before Lordship, my lord. And like the petitioner allegation is that the procurement cell has committed a mistake that he has not registered there now, and also they are not allowed to participate. He is not allowed to participate because of the deficiency of the license. License is not mandatory, my lord, as per the this is the clause, my lord, in the tender paper. That's why he came before us.
Was suppose if somebody is registered in the government portal, does any license is issued?
Well, license after because license issued.
Registration is one concept, and the license is another concept.
The license is not mandatory, my lord, in this case. License issued. No, license is required after.
Please try to understand that I am making observation for your benefit. I am asking this.
Yes, my lord.
I am asking these questions to them.
Yes.
That whether the registration is issued as a license to participate or what?
No, the registration gives a right and authority to participate in different tenders of the government, including also the tender portal by the government.
But will you not reflect that since you are not a registered contractor, you are not eligible to participate in the tender? You could have written it.
So he has not submitted bid at all. That's what I want to point out.
Oh,
Ma'am, let me just clarify.
Kindly see page
Miss Tripathi, senior counsel is
yes.
submitting,
Page
please.
61 says the rejection with regard to his registration in the government portal,
Oh, this is
not
what?
the and
Then-
this
License has not been uploaded. This license means what? What license?
That's the opposite fact number 4.
Yes,
That's
yes.
the Odisha State Procurement Cell who is to register in the government e-portal. Only if the lordship reads my.
Then what is the meaning of that license?
My lords, if I may explain, my lords, that
I just
point.
wanted to understand what is the meaning
Yes.
of the word license.
My lords, if I
License is
elaborate
something
on
different and this
Registration
registration
is different.
different.
Yes, my lords.
This is what? What is that
Yes,
license?
if I may elaborate minutes when while creating a profile in the e-portal, he has to mention the nature of business, in which he had mentioned his nature of business is transportation. So therefore, in support of that claim, he had to upload a transport license, which he had not uploaded. So therefore, he was requested that to revise the profile, but that profile cannot be revised if it is not rejected and a new profile is created. So that's why his profile was rejected, so as to give him an opportunity to create a new profile and upload the transport license. Thereafter, he could have participated in the tender. Now, my representative, he had visited the office, he had inquired about this, wherein he said that fine, I'll revise the portal and I'll upload the transport license. And accordingly, he was told that fine, you revise, accordingly you can participate in the bid. Thereafter, he sent an email saying that the revision has been done. But then, my lords, when the help desk team of the e-procurement cell verified, they did not find any such amended profile or revision profile in the portal. Therefore, my lords, and he had also stated that you can profile, I'll create a new profile and then upload the transportation license. That is not there, my lords, because we verified, my lords, if I may share the instructions.
So why are you not using it as an affidavit?
Yes, well, it's file an affidavit. We just recently received the instructions. We'll file a counter affidavit, Malik, on this.
But now 4 has to.
Well, it's paragraph 8 and 9. Paragraph 8 and 9 of our instructions.
Where is that mail?
What is it mail? So mail was sent by the petitioner, my
Where is
lords,
that 155?
stating that he has already amended.
That email?
What is it? What is the email?
You have not included.
The email is not there, my lords, but the.
Why? It's a very important thing.
Yes, my lords.
That he wanted to change it from a transport member and then say, I'm going to file a revised one.
What is this document?
Let's write that.
What is this document? Last page.
This is the profile which he had created in the portal, wherein the nature of business says transportation. Yes, ma'am.
Actually, he did not participate in the tender. He could
No,
not.
ma'am.
Only if your lordship perused paragraph 7 and 9 of my affidavit, I have clarified. Once he is not there, so my question of we not considering doesn't arise at all. And he cannot stall the tender process because he has not been registered in the e-portal, which has been rejected rightly or wrong.
That
And
is
that
our case.
cannot be a ground to stall the tender process.
That is our case because we have been prohibited because the registration could not be done and also the procurement could not be our paper could not be accepted by the procurement cell. The opposite part number 4 has to say. Opposite part number 4 has to file the affidavit in this regard. Nowhere it has been stated the license is required.
tender document which you
Fine,
obtained.
document he can
Document is-
download after the
Yes,
registration.
yes.
He cannot upload unless he has a registration within us.
I have
DSC.
DSC.
He can,
DSC.
yes, he can
DSC
download,
register.
but he cannot upload unless he has a registration.
Because
That is the
you
difficulty.
know,
So he has not submitted.
this
And this signed
the
tender also is available in
documents I have submitted my could not because I have been deprived of, I am prohibited. And also let the opposition 4 file the affidavit in this regard, the procurement cell. Which I have my case is that only the procurement cell is committed mistake with my registering and also this accepting my document. My
And
document I have
he
submitted.
can adjudicate his
And how I shall
but the
participate?
tender process may not
That
be
I have been
solved
prohibited to
as
participate. I have been prohibited to participate.
but it can.
He is saying that I am not participated. How can that is my case? That I have not participated because of this, because I have prohibited. That is my right, my lord. Amount has been taken away because I've been. Stated anywhere that I have participated. I have been deprived. I am prohibited to participate. I have stated so because of their wrong commission.
Minutes may
This is my prayer, my lord, and I have prayed like this. And only the opposite partner of who is the right person. He has to give the affidavit counter in this regard, my lord.
Minutes, may I make one humble submission, Minutes? At page number 12 of my intervention application, Minutes, I have given the minutes of meeting in which the details of the tender bidders who have participated is given. In the details, if your lordship will see page number 12 and 13, his name is not there. In the technical bid detail summary report, his name is not there. He is relying on clause 5.
How his name will be there?
Yes, he is
Unless he submit the tender document, his name will not be there. So what is the charge in this? He himself is admitting that I have not submitted the
Yes,
tender
So,
document.
clause 5.10 is concern belows that only governs the bidders who participate in the technical bid. In the top of clause 5, if your lordship will see, that clearly states that that will govern only after technical bid, Millets. That will not govern his case.
I have no allegation against. Only I have allegation. Who has not entered evidence. Only he is filed affidavit in his figure. Why I am restricted to participate only because of due to the non-registration as well as non-acceptance of my tender proposal. Only procurement shall has to accept the procure the documents after registration like this. Two things he has to do. Thereafter, my tender proposal is processed by the authority. This is that in the initial stage I am restricted.
So paragraph 7. Paragraph 7 of your counter.
Today received the counter, I find the tender. 5 paragraphs, I am going to read clear process. Let your lordship decide. There are 4 paragraphs I have stated. Paragraph 5, very level, and permitted to read on human. As far the terms and conditions and the eligibility criteria, the petitioner inserted all the required data into the portal on 12/33/2026, which is within the time stipulation given in the tender. It is a strange that although the data were uploaded, but due to some reason best known to them, the registration not to be done in spite of intimation given to the petitioner that your registration request is yet to be approved. In the said intimation letter, it has been reflected that the PAN certificate, registration, VAT certificate, registration GST certificate are inserted. Accordingly, the petitioner waited for registration, but due to delay for registration, he inquired about the non-acceptance of the data in the portal. Lastly, he was intimated that due to non-submission of labor license, although not mandatory, the registration through portal could not be successfully done. The copies of the documents related to also they should proceed. Thereafter, paragraph 5, the petitioner submitted the representation to the Chairman District Tender Committee, Sundargarh, with the copies of concerned authority for illegalities committed for non to the tender notice 27/2/2006 and requested to allow him to participate in the tender process or to make a retender by way of the petitioner can participate. He has also drawn attention to the wrong interpretation clause 5.10 by which the constitutional right and the legal right has been taken away. Only prayer, I have prayer like this, Your Lordship. There is therefore prayer there. His Honorable Court make recess please to party to show as to why the registration for participation in the tender by tender number 526/27/2026 of shall not be allowed, and in the absence of registration or deprivation of the participation in the tender process shall not be cancelled. And as to why the fresh tender shall not be floated, in my Lord, this is my prayer, and this is only I have never stated anywhere that I have participated, but from the threshold, from the Judicial, I have been restricted because my constitutional right, my only to participate in the tender has been taken away, and I have tried my best to upload, but because of the non-registration, that is the only non-registration is in only efficiency license. License is not required in the also in the tender system, government procurement system national. I have also downloaded. Nowhere it has been stated that the license is basically required for the registration. And I have only because of this participation in this tender, I have only requested to my registration should be done as well as my the tender paper should be accepted, procured. The procurement cell has not restricted me and prohibited me, right? And this is my mind of prayer, and Your Lordship rightly, my Lord, interpret in this case, and also this unless until the opposite part number 4, there is a file an affidavit, my Lord, how this cannot be. This is my prayer.
I'm represent. I'll file an affidavit, to bring our side.
You are the tendering authority. You are the tendering authority.
Yes, paragraph 6, the dates I have furnished is already over. He is trying to leave the tender and the registration. And prayer is explicit also. Register coming to participate. That tender is over. He can participate in any tender.
Registration body is someone else.
Yes.
And you derive the data from that registration.
Registration and also tender. Multiple hold the rejection of registration is illegal. He can participate in future tender. But so far as this tender is concerned, it is already over. The timeline is over. That's what I get point out to you.
Mileage, he has the chance to revise, upload a revised profile also.
This is regarding this tender
submitting the
and
then his profile would be, he would be
I have
registered
uploaded
subsequently.
and registration should be done simultaneously. Procurement cell has to register as well as the procure all the tender papers. There is nobody except the tender procurement cell. Nobody has to accept the tender paper, and he is the right person, the authority. Only he has to say. I have no allegation against the authority, tender authority. Only the processing unit is the procurement cell who has to give the tender paper to the authority for process. And he has done committed mistake, and I have been restricted.
Yes. Yes, sir. That's all.
Maybe I have experience in this line, and I am doing this work. This the opposite partner for procurement cell has not filed affidavit.
My let's may take our instructions under consideration.
We'll take into consideration only OPWD code.
Yes. My let's we are bound by procedural.
Their own document.
Yes, my we are bound by procedural formalities. He was given the option to revise his amended profile, but he did.
Let us see, let us see. Actually,
Before the last person.
Mad.
I'll give you that. Yes, we'll Please.
Okay.
At the time of admission of the insurance petition, it was argued on behalf of the petitioner Now you want addition? Yes, in view of the dismissal of the writ petition, the interlocutory application seeking addition becomes infructuous and is a covered case. Yes.
Madam.
Weekly list. Item number 1.
What is this OGC? OGC.
Therefore, plot which allotment of a plot of land at Chandrasekharpur. This was allotted in my favor. There was no communication for deposit of the amount. Subsequently,
It was allotted.
Ma'am?
When it was allotted?
Lottery was held in 1989, Your Lordship.
89.
Yes, 90 it was published. In fact, Reasonable Court also allowed my claim, saying that I should deposit the current benchmark valuation amount and it should be done. But that was passed in the shape of an interim order, not a final order. The state challenged it for the Honorable Appeals Court. Honorable Appeals Court held that this should not be adjudicated in the shape of an interim relief. This should be adjudicated in the shape of a final relief. And that is how the matter has come back again before your Lordship. Now, their only stand in the counter affidavit is that they have communicated to me and I have not responded. They have neither produced any document or any communication before your Lordship. There is no tangible document before your Lordship. And the rejection has came in 2001 and 2002 I have challenged. Even today, the plot is vacant. It has not been allocated to anyone. I am also ready to deposit that benchmark valuation. And if your Lordship peruses the order passed by this noble court,
Success.
if your lordship permits, my lord, he two orders I beg to draw your lordship's attention, kind attention, though it has been interfered with by the Honorable Appellate Court, 8/11/2019.
No, those have gone. I have
Ma'am,
seen
those
the
are
order of
gone.
the Supreme.
Ma'am,
Those have
but-
gone. Says
ma'am.
that if you want to pass an order, finally you hear out the matter, not at the interlocutory stage.
Absolutely not, madam. Your lordship will decide finally. Madam, he is serving in army as a driver. You are 30-year-old when he applied. Madam, and now, madam, he is on the verge of retirement, only 4 years left. Now, madam, the
He was
struggle
80
for
years of age when he applied. 80 or 80?
30. 30
Third,
years.
okay.
But now
I
he
heard
will
80. I was surprised and shocked. And yes.
And your lordship sees even the rejection has come only in 2000, in the month of August 2001. My
Where
lord,
is that? Where is that?
and that is annexure 4, my lord.
Page?
My lord, that is page, your lordship 23.
Oh, it says that it was allotted, but he has neither deposited the premium nor executed the lease deed, so it is
That
rejected.
is on the premises that it was communicated to me through registered post and I did not respond to it. In my repetition as well as in the rejoinder,
See
I
the
have-
order, page 23, it is relevant to at this juncture, and also see page 19, which is
Ma'am,
where
may I
terms
just-
and conditions are set out, page 19.
Whatever, we'll see to it. Yes.
let me just assist one more point. My lord, I have in the repetition as well as in my rejoinder specifically stated that though they told me that they have communicated through registered post, let them produce any kind of document that either there has been a communication or registered post received. That is my stand in the repetition. Your lordship will find page 6, paragraph 5. My lord, their stand in the counter affidavit is at running page 25, paragraph 4. They say they have communicated through registered post, but no receipt, no communication, nothing is produced for your lordship to justify such stand. And that is one of the factors which weighed in the mind of reasonable court while passing, though unfortunately at an interlocutory stage instead of a final disposal. So that is what, my lord, was interfered with by the Honorable Appellate Court because it was passed in an interlocutory stage and they
So
took a
according
stand.
to you, that once you have not been communicated of the allotment,
Allotment regarding the deposit of premium amount,
no,
which others
premium-
have been communicated.
others have been communicated.
Where there was a lottery, the names were published under Annexure 2. Your lordship will see that is Annexure 3. The publication was made. Thereafter, each allottee was communicated and they deposited. So far as I am concerned, there is no communication, no proof of communication. And that is why when they filed a recall petition to the interim order earlier passed, the reasonable court took note of everything and said, and they cited certain authorities also saying that no, we have communicated, so therefore it cannot be directed this way.
So have they, how they have communicated by registered post?
They have asserted registered post, but they have not.
Have they annexed the postal receipt?
Absolutely not, your lordship. Absolutely not. Except the bald assertion in the counter affidavit at page running page 25, paragraph 4. Nothing, my lord. Comment, if your lordship see the scheme that is page 19, allotment of government land in the new capital for the residential purpose 1987. So this was
No, one of the orders I've seen. Order number 5 in 2019.
2019 you will see.
This was to accuracy. And another one is 18/10/2019.
Which one was challenged before the Supreme Court?
Miller?
Which order was challenged before?
Order dated 2/8/2019. My lord, then 18/10/2019.
Before the Supreme Court.
Before the Supreme Court, order dated 8/11/2019 was challenged.
8/11.
My lord. Apart from that, two other orders, namely 2/8/2019 and 18/10/2019.
18/10/2019.
This was also challenged.
My lord, that is what the SLP order indicates.
Show us that if you have communicated, have they accepted that they communicated to each of the petitioner by registered post?
No, they have asserted, so far as I am concerned, and I am only one petitioner of your lordship, they have asserted that they have communicated to registered post. That stand your lordship will find running page 25, paragraph 4. Paragraph 4, your lordship. Towards the middle portion was communicated to the petitioner by registered post in the address furnished.
Yes, that's the small issue.
Yes,
To us,
we have not produced the AD Miller because Miller's will appeal.
not a question of acknowledgement due card, question of postal receipt.
Miller's, we do not, Miller, it is not produced. It is not annexed to rate petition,
No.
it was not produced. But
Then
Miller's,
how can a presumption be drawn?
the allotment was made in the year 1990. This rate petition came to be filed in the year 2002, Miller's, after 12 years.
Because visualize the situation, sir. If somebody does not know that what
No,
he has to
he
do.
admits that it was in his knowledge. In fact, Miller's has annexed a newspaper publication. That was to find at page 21. The petitioners in the number allotted to the petitioner also finds place in the publication. It was widely published in the daily locals. The petitioner admits he had knowledge. But Miller's, he kept quiet until 2002 Miller's. He had approached in time. Miller's, after 12 years, Miller's, it may not be possible to retain every postal receipt.
Oh,
Miller's, had he approached in the year 1990 or any time between those 12 years, Miller's, we have stated on affidavit. If my lord should say the counter affidavit, we state on affidavit it was issued Miller to registered post.
but there must be some documents mere assertion will not do. And they have denied in the rejoinder.
Yes, it's also in the writ petition itself. My deny also in the rejoinder. I have said let them produce the documentary evidence that I have asserted in my rejoinder also.
At this junction, Miller, this is one question. Another aspect, Miller, my lord should kindly see, what terms and conditions, because that is relevant because of that aspect an order has been given by the Honorable Apex Court, which will draw a law's attention to. My lord should kindly have page number.
What are the
Page
essential?
19, page 19 Miller. Page 19 Miller. 2B. Miller, this is extremely relevant. B Miller.
Yes.
The allotment which is allowed 60 days prior to the date of receipt of the allotment order to deposit the premium.
Correct. This is
for
on the
land.
receipt of the allotment order.
Yes, Millers. Which Millers we say that you have communicated to registered post.
Correct.
Because here there is a right double. It says that for the land for submission of the original specific challan in book of the deposit, if the premium is not the allowed 50 days more than the deposit of premium in the last date of submission, but for each additional area per year's penalty. If it does not pay the premium of penalty within the expected period of 15 days, then the allotment order shall automatically lapse. So after 12 years, the place will automatically lapse. Again, there is another aspect. Again, say that the lease is not executed within a few more days. Again, the idea is that it will automatically lapse. Relying on this, the Honorable Apex Court in another identical matter has held that it was automatically lapsed. That we have given my lord should have the IA filed by the state.
What is that order?
My lord, at flag D, there is an IA filed by the state. At flag D.
That was in Maluti Biswal. Maluti Biswal.
Yes, sir.
That was in fact referred to and distinguished, saying that that has got no application.
Look, sir, there is an order annexed at page 12 below. Sorry. But Maruti Vishwas, please. So let's see, page 3 of and in the next page, the conclusion will also the honorable.
But there was no
Milord,
issue that
the
it was not
honorable
communicated. This
Yes, Milord.
this
But
issue
because
was
we
that
Milord, an affidavit
there
said that we
there in
communicated.
Maruti Biswal, the husband was also allotted a plot
Yes, Milord. What
and
the
he
honorable-
deposited.
Yes, Milord.
So
What
that-
the honorable Vijay Court has asked on Milord is only the delay factor. Milord, this is the last of the conclusion, Milord. No reason has been shown, good or bad or otherwise, why there was so much delay in approaching the court. So, Milord,
Then you issued an order in 2001 for
Milord,
for cancel.
he approached. So he has approached after 12 years.
What approach?
He has, Milord,
You have
Milord, he
issued a
kept
letter.
silent. He kept silent.
No, why you issued a letter of cancellation in 2001?
Milord, because he filed an application before the chief minister that I am not being allotted a plot. That was forwarded to us. We had to take an order. Therefore, we said, Milord. Therefore, Milord, we said that there has been complete silence on your part for 11 years, and it is automatically lapsed. So, Milord, from 1990 to 2001, Milord, the petition has not shown any kind of Milord approach or any kind of urgency. He has not, Milord, he had basically it's a case of negligence, Milord. He has slept over his right. We, Milord, on the contrary, we have filed an affidavit. We have stated that we have issued it with registered post, Milord.
We'll pass the order.
Only thing I was pointing out, if the Lordship only happened when you permit me, that was only a indication of publication of allotment, no premium.